sooner.
Thank you.
I don't think so. Hamilton, please. Thank you. And we're live on YouTube, Ms. Rolak.
Good morning, Judge. Thank you.
You're welcome. I'm fine. Probably is helpful for the participants if the person talking is big, the people here in court, but I don't, to make a difference to you all, who, whether the way it's set up right now, the speaker gets big on the screen. I think if we were having some kind of hearing, that would be helpful. Let's leave it this way for now, if it gets weird. All right. Good morning, Mr. Hamilton.
Hey, good morning.
So it's good to see you. You got brought over here because we were going to be talking about your case, and today was not, excuse me, a day where I had Zoom space over at the jail. So we're not going to do a whole lot that's substantive with your case, but because we're talking about it, we thought it was important. You knew that we're doing what we can to make some progress. Ms. Patel, your lawyer, sitting by your side. Ms. Winfrey is on the screen there. That's not Ms. Winfrey, the big screen, that's Ms. Rolak, but Ms. Winfrey is there. She just nodded. And if she speaks, she'll become the big square probably. But either way, the important thing is she's here so that I can talk to you and your lawyer about your case. I believe that I have ruled on all of the motions. The state had some motions, the defense had some pretrial motions, other than motions in limine. These were more substantive, evidentiary or legal matters that understandably both sides wanted to have resolved before we got to the point of, well, it's trial time, because that might affect the way negotiations went. Ms. Winfrey, are you aware of any motions that I have not ruled on, or do you feel like we're ready for this to get to trial when we start trying cases?
Yes, Your Honor. I believe you've ruled on all the motions that the state has presented, and also I believe from the defense, and the only outstanding matters would be motions in limine prior to trial.
Okay. Your same understanding, Ms. Patel?
Yes, Your Honor.
Okay. The one matter, Mr. Hamilton, just give me 1 sec. You guys can chat in a second. That was brought to my attention in the last week or so is that Ms. Patel asked that I sign an order that would let her and or her investigator bring a laptop into the jail so that you could review some of the discovery that is not good on paper because it's someone's interview or I don't know what it is, but it's the kinds of things that certainly your lawyer was entitled to and that your lawyer thinks ought to take a look at, either to help her prepare or to help you think about, ooh, this case is not going so well or the case is looking good. Either way, you're entitled to review the discovery. It just happens to be digital and not paper-based. So I've signed that order, and Ms. Patel and or her investigator should be able to come see you soon to go over that. And I think that was the main thing that was still bubbling for you, Ms. Patel, is that correct?
Yes, there is one new thing I wanted to make Ms. Winfrey and Your Honor aware of. It came to my knowledge sometime last month that Mr. Hamilton is a veteran. We did do a veteran court referral, and we are waiting from them. And we may then try to put it up for a plea before Your Honor.
Okay. Ms. Winfrey, my printer's running, so it may have been hard for you to hear what Ms. Patel was saying. Could you hear her?
No, I could not hear her, Judge.
Okay. She explained that her office has completed the referral paperwork to have Mr. Hamilton considered as a participant in Veterans Court. And if Veterans Court accepts Mr. Hamilton, then there's a possibility that they may put up as a non-negotiated plea, a plea, part of which I guess the defense recommendation would be that Mr. Hamilton participate in Veterans Court. As I understand it, Ms. Patel, Veterans Court hasn't said yes or no. They are processing the referral.
Correct.
Okay. I guess if Veterans Court says no, it's a non-starter for the defense. If they say yes, then it may be that Ms. Patel asks to get Mr. Hamilton on a calendar for a non-negotiated plea. But I trust Ms. Patel will talk to you about that if and when Veterans Court says that they're interested in possibly having Mr. Hamilton as a client. Anything else, Ms. Patel?
No, Your Honor.
Any sense of when you'd be able to see Mr. Hamilton? Are we talking a few days, a few weeks?
I'm not sure that they'll really give me an indication on scheduling, but I will send them the order today to see when we could make that go into motion.
Okay, the point is it's in the works and you've got the order now. So hopefully that will make some stuff happen. Ms. Winfrey, anything else in Mr. Hamilton's case?
No, Your Honor, not from the state. Thank you.
All right, Mr. Hamilton, any questions for me?
No, sir.
Okay, well, Ms. Patel will be out to see you soon and we will go from there. I have one question, Ms. Winfrey. Well, how long do you think it would take to present the state's case in chief if this were a trial? Ballpark. I'm putting you on the spot, so I'm not holding you, but hey, down to the minute. But is
Yes.
it a 1 day? Is it a 9 day? What do you think?
It's a probably at least a 5-day.
Okay. All right. Based on what we've discussed about the nature of the allegations, I can understand that. All right. I appreciate that. Mr. Hamilton, we'll keep trucking with your case and it'll get on a calendar either because it's time for trial or because you and Ms. Patel have decided you're going to put it up for a plea. We'll
Yes,
see
sir.
that. Okay.
Okay.
Thank you, Ms. Patel.
Thank you, Judge.
Thank you, Judge.
Ms. Winfrey.
May I be excused?
Yes, ma'am.
Thank you.
Mr. Franklin. Good morning. Are you going to handle Mr. Cox's revocation? Great. He is the other gentleman in custody, and that's all we've got left this morning. So do you need a chance to talk with him?
I spoke to him yesterday,
Well, thank you for doing that.
so, and I've already discussed it with, Ms. Hall.
Okay, I see Ms. Hall on the screen. Well, we'll get Mr. Cox out here.
Good morning, Judge.
Good morning. How are you?
I'm good. How are you?
I'm okay. You sound subdued. Did you have a good weekend?
No, I'm fine.
Okay.
Just in the morning.
Thanks, Ms. Patel.
Thank you, Judge.
If there's an issue with the order, let me know, but I'm guessing that now it's just a question of when you can get out there.
Correct. It is clear for make sure the let it go.
Okay. Okay. Did you want to, I'm not ignoring you. You're waiting for Mr. Cox also?
Mhm.
Okay, what does your mask say?
Public defenders are essential.
Right. I'm trying to get one of the Fulton County ones. Where did, Ms. Patel, where'd you get your Fulton County one?
They left them on every attorney, or every employee in our office.
Yeah, every once in a while, we'll come in, we'll have a Ziploc bag, gloves,
Right.
paper mask, we had those.
We get bubkas.
Yes, sir.
All right, let's go on the record. This is, are you Mr. Cox?
Yes, sir.
Hey, Mr. Cox, I'm Judge McBurney. You doing okay?
Yeah.
You want to go forward today? We're going to have a conversation. I don't know that we're necessarily going to resolve anything, but we're certainly going to talk about a probation revocation. Are you okay going forward?
Yes, sir.
Okay. Well, Mr. Cox, we're here because I signed in August a warrant for your arrest. There's an allegation that while you were on probation for a case here in Fulton, 17 SC 152341, it's an aggravated assault case. While you were on probation, you were arrested in Clayton County for a firearm offense and maybe misdemeanor marijuana. So in other words, you're on probation for the Fulton case and you allegedly got in trouble in Clayton County, which would be a violation of your probation. I'm going to ask your lawyer, Mr. Franklin, a few questions about things. The prosecutor, Ms. Hall, is on the screen there, and we'll figure out if we're sorting your situation out today or if we're going to need to have a hearing in the next few days to talk more substantively about the Clayton situation. So, Mr. Franklin, is Mr. Cox admitting to these allegations or is he contesting them? I don't know if the Clayton case has already been resolved or where we are, so I'm turning to you.
The Clayton case has not yet been resolved. I believe Ms. Hall has an announcement to make regarding the status of the probation.
Okay.
Yes, Your Honor. The defendant's probation revocation case expired August the 16th of 2017. And I got the information from Ms. Crawford. So there's actually nothing that we should be doing today because that case is closed out.
So I'll look it up. That math doesn't quite work because it's a 2017, unless he was on probation for 1 month. It couldn't have expired in 2017. It was a 2017 case.
I have a copy of the disposition sheet. We weren't sure who was handling the case, so Ms. Snyder from the conflict office had printed up some stuff in preparation in case she had to handle it.
Sure.
She gave me a copy of what she had this morning.
Okay.
It appears that it was about August 17th, but it was filed on August 18th. He pled to a 5 to serve 1 year balance of probation to be probated. The 1 year was, it says commuted, but reduced to time served.
Sure.
So essentially, it appears to have been a 4-year probated sentence.
Back in 2017.
That's what it looks like, yes, sir.
Okay. But then that would mean he's still on probation.
To 18, 19 to 20, it would appear there's a year.
Left.
It would appear so, yes, sir.
Okay. Well, let me ask Ms. Crawford, because I'm confused. What I thought I just heard Ms. Hall say is that, in fact, okay, here Ms. Crawford is saying that his case expired on August 16th, 2017, but that can't. Ms. Crawford, maybe you can help me understand, because Odyssey is being difficult right now, but it's a 2017 case, and if he pled 5-1 balance probated, that 4 years probation, it may have ended early, and I'm all right with that, but I don't understand how it could have ended in 2017.
I don't understand either, Judge, because when I checked it last week, it said that it had 10 months remaining. But when I just went, I don't know if they adjusted the time. I don't know what happened, but it says that it ended August the 16th of 2017. So I would have to call someone downtown to see if they did some type of adjustment or something, because I
Yeah,
don't know.
Reading the special conditions of probation, I can pass it to you when I'm done reading it. There is defendant waives Fourth Amendment rights, must successfully complete the Visions Unlimited program. I think the judge you may recall Ms. Sands in that program. He must successfully complete the program and be in attendance for a minimum of 2 years. Balance may be suspended after successful completion of the program and 1 year compliance. From what I've spoken to Mr. Cox about, it appears he was a model probationer. I don't believe he has any violations. At the time of his arrest, he was working as a forklift driver at a Deco. He's a father of 2. He stayed out of trouble. This arrest being the only encounter he's had. So 3 years would be time enough for him to have theoretically completed the Visions Unlimited to the extent he was able to complete it, because I think because of other cases with other people.
But I also want to make sure, I'm sorry to interrupt you, but I've now, Odyssey has turned back on for me. There are 2 defendants from the 17 SC case. I assume they're brothers, Jaleel and Jure. The warrant I have is for Jure.
This is Jure.
You're Jure Cox, because our calendar says Jaleel. But Jure Cox is the gentleman seated here. So that's the one I'll look at.
Yeah, Miss Nelson reached out to us last week and let us know that the wrong name was on the calendar.
Okay.
And this is the correct defendant for the correct warrant.
All right. And Jaleel would be
his twin brother.
His twin brother. Okay. So I'm seeing if it will pull up the case to see what Odyssey says. Mr. Cox, how long have you been in custody based on this warrant?
1 month.
1 month?
Yes, sir.
Okay. So it's interesting. It's actually a 15-year sentence. There's a suspended 10-year term that's not at play right now, but there's more. And it was judged down, so it's Visions Unlimited. Okay. Well, Odyssey is not letting me in any further. Ms. Crawford, tell me the process you need to work through to understand this better, because I trust the system says what you're telling me, but it's not possible because this plea was taken on August 17th, and the info you're looking at says that his case expired the day before he took his plea.
Okay, so which one are we looking at? Are we looking at Jure Cox now? Because I didn't look Jure Cox up.
Yes, ma'am. Jure Cox. So you were probably looking at what was on the calendar.
That's correct.
And that's not the right person. It's Jure. That the warrant is for Jure. I have Jure Cox sitting with me.
So Jure still has time remaining on his case. His case expires in 2021. So let me pull up the time for that.
So it may be that your client's brother got a sentence of time served with no probation. I don't know, but that's the wrong.
Okay, so this client does have 10 months and 4 days remaining on his case.
Okay. So it's a slightly different scenario. What do you want to have happen today for Jure Cox?
We are not contesting the allegations. We've reached an agreement to continue Jure Cox on probation. He's made his bond in Clayton County. And as I understand, the circumstances that brought us here are that he was pulled over for an illegal lane change. Officer says he smelled marijuana. They searched the car, and a firearm is found in a bag. There are 2 other persons in the car, and I believe somebody else has already indicated that the gun is theirs.
Was your client driving the car or in the car?
He was driving the car.
Okay. Ms. Hall, are you able to hear Mr. Franklin?
Yes, Your Honor.
Great. All right. So we've got a slightly different situation. The allegations are not changed. The good things Mr. Jure Cox has been doing haven't changed. The unfortunate circumstances in June of this year have not changed. What's changed is that Jure Cox actually does have 10 months left on his probation. Is it the state's recommendation as well that Mr. Jure Cox be continued on probation?
Yes, Your Honor.
Okay, all right. Ms. Crawford, do you have anything in your system that suggests that Jure Cox had any issues while on probation other than this arrest out of Clayton?
Give me 1 second, Judge, to look. Doesn't look like he was ever in violation. He was compliant, other
Okay.
than discharge. Yes, sir.
Mr. Cox, did you end up doing anything with Visions Unlimited?
Yes, sir.
What kinds of things?
We was getting job searches and we were doing GED.
Okay, did you get your GED?
You know, I had 2 children at the time, so my money was kind of low, and then I pay bills, and I have a car note and insurance. So my money, I'm the only one working, so my money is kind of like it's not there with, you know, you have to pay for the GED.
Right, it's not free.
Yeah, so
Okay.
it's kind of hard. But I had 2 little babies at the time, so
Okay, so how many kids do you still? Yeah, you still have 2 kids.
a 1-year-old and a 2-year-old.
Okay, do you have more kids now or just those 2
Just
kids?
those 2.
Okay, and mom takes care of them and you work?
Yes, sir.
Okay, and you were most recently working, doing forklift work at the facility, Mr. Franklin?
Yes, because no one we had to pay for daycare, and I'm the only one working, and it's hard for us to you know, the money from one person working. Nobody wants to watch our kids unless we pay them, so it's kind of hard.
Sure. Were you doing daycare because your children's mother was trying to work also?
Yes, at one point in time, I was getting unemployment, and she was working, and I was watching the kids. Then
Okay.
I stopped getting unemployment and went back to work and let her get unemployment and watch the kids. So we take turns because it's kind of hard. As a
Sure.
young parent, it's kind of hard.
It is very hard with a 1-year-old and a 2-year-old. Do you know about the availability of your job now? You've been away for a month.
Yes, I've been keeping update. They waiting on me. Yes.
So you think they'll take you back?
They will. Yes, sir.
Okay,
I know that. Yes, sir. They will.
all right. Are you still at the East Fayetteville Road address?
Yes, sir.
Okay, is that a house or an apartment?
House.
Okay, and who lives there besides your 2 kids and their mother?
Her grandmother.
Is it her grandmother's house?
Yes, sir.
So it's a safe place, meaning you don't need to worry that because you weren't able to pay rent for a month, you got kicked out.
Yeah, I won't get kicked out. No.
Okay, you can get back there and start helping
Yeah,
them.
because we had the kids, she wouldn't just put us out. She'll give us time to pay the rent.
Good. But she lives there also. Grandma lives
Yeah,
there also.
me, grandma, my girlfriend, and my 2 kids. Yes.
All right. And what do you know, Mr. Franklin, about the Clayton situation? It has even been in, nothing to be indicted.
Can't be indicted. I believe he was improperly charged. They charged him possession of a firearm by a convicted felon. He's a first offender, so that's a small thing.
Okay. And someone may be stepping forward to say, it was my gun.
Correct.
All right. So, Mr. Cox, I guess the lesson from this is you got to be thoughtful about who gets in your car, or at least what they bring into your car. And the guy may have had a backpack and you're not going to search their bags, but excuse me, while you're on probation, this kind of thing, as you've now learned, you last a month from being around your kids and supporting your family, can get kind of messy. And folks are going to be watching you more closely. You got first offender probation on what looked like some pretty serious charges. I'm not familiar with the 2017 case, but at least the way it's charged, it sounds pretty serious. Knowing the judge who sentenced you, it sounds like she was giving you a second chance, but was a little nervous about it because she wanted anything that came up with your case coming back to her. She's retired, so it's coming back to me instead. What I'm gonna do, Mr. Cox, in light of your arrest, which would be a violation of your probation, is that I'm gonna revoke 30 days of your probation, but I'll reduce that to the time served. So you may have done 29 days, you may have done 35 days, but I'm revoking 30 days. I'll reduce that to the time you've already served, and then I'll continue you on probation. You don't have much left. And if you can successfully complete it, this remains not on your record. And so getting a job like the job you have now will be a whole lot easier, because you'll be able to say, I don't have a felony. You don't have a felony right now. And if you can get through the next 9 months and 4 days, you will continue not to have a felony. And that will be a big distinction between you and other folks who may be applying for some of these jobs. Does that make sense?
So you said, so stay in jail for 30 more days?
No, sir. You've been in jail for about 30 days, it sounds like. When did you get arrested?
August 10th. I mean, not August 10th, September 10th.
Okay, so you've been in jail for 33 days or so.
Yeah.
I'm saying that those 33 days are your penalty for having gotten arrested in Clayton, for maybe having weed in the car, and maybe some other guy had a gun in the car. So you've done that time. You should get out today or tomorrow. If you don't get out today or tomorrow, you call Mr. Franklin, he'll let me know, and we'll make sure that you get out. But these last 30 days that I trust you have not enjoyed are the sort of wake up call of, hey, you got to be careful who you let in your car.
I've been praying and crying every day.
All right. Well, I want you to get back to your family. It sounds like you've done real well on probation. How's your twin brother doing?
He's real better than me right now.
Well, right now, no doubt. But is he working?
Yes, sir.
Does he have kids?
Yes, sir.
How many kids does he have?
Just one.
Just one. He was smarter, huh? Okay. But he's got a good place to stay.
Yes, sir.
All right. Are you guys close?
Well, not since we got kids. You know, we don't really talk as much, but I mean, we don't really see each other as much, but we talk.
Get your hands full.
Yeah.
Okay. Well, keep your hands full with good stuff. And we'll handle it that way. You'll have a little bit more probation left, but like I said, if you can get through it, this whole first offender thing, there'll be nothing on your record, and that will really help as you try to go in the direction it sounds like you want to go for your family. Okay. Mr. Franklin, anything else for Jure Cox?
No, sir.
Ms. Hall?
Nothing further from the state, Your Honor.
All right, Ms. Crawford, did what I said make sense in terms of the order that I need to sign?
Yes, Judge, I'm going to revoke 30 days, reduce the time served, and continue him on probation.
Yes, ma'am.
All right, thank you.
Thank you. Well, thank you for clearing that up. It does sound like probably not the first time Jure and Zalil have gotten their situations crisscrossed. I think that's it for this morning. Before you go, Mr. Franklin, if we could just get a preview for this afternoon.
We've worked out a negotiated plea on both cases for Mr. LeBlanc.
Excellent. Okay. We can do that this morning if he's coming in.
He wanted to physically come in. He has an ankle monitor. He just wants to make sure it goes through and it's not any technical stuff. So
I'm fine doing it at 1:30. I'll be here at 1:30. I just was offering it up if people wanted to have it happen sooner.
I'll give him a call and see what he wants, if we can get it figured out.
Just check with him and see what he says. And if he wants to come in now, we'll do it. Otherwise, it's on my calendar for 1:30.
Okay. Additionally, a case that we put into judicial hold a month or so back, Levertville may show up. I've gotten back in touch with his sister. This is the guy who lived in Stone Mountain and I rode out there.
Yeah, and then
he's back around. I'm trying to get him. He said he would come in this morning.
He's supposed to have a drug court or a
He needs to be interviewed by behavioral health court.
Yeah.
And I've already talked to them. I haven't heard back about when they'll be able to. They knew that we were trying to get them in this morning, but we got a lot of things cooking at the same time with that.
Okay, well, that's a good update that there's contact. We'll see what happens.
Yeah.
Okay, we'll check with Mr. LeBlanc. Again, no pressure. Don't tell him Judge wants you down here.
Understood.
We can do it this morning or we'll do it at 1:30.
Okay. And just to make sure, the other two matters on the calendar, Ms. Hall already announced.
Well, I announced, I've already signed the null pros for Mr. Martin. Is that Mr. Martin?
Yep.
Hey, Mr. Martin, your charges have been dismissed. So you're good to go. You took care of what you needed to in your PTI agreement, and the same with Ms. Smiley. And I confirm those were both entered. All right, Mr. Martin, you got any questions? All right, be safe. Yep. All right, so I will sit tight. You see if you can reach Mr. LeBlanc and we'll make a plan.
He's gonna zoom in, Your Honor, log in and get on.
Okay. Ms. Hall, are you comfortable doing the pleas in Mr. LeBlanc's cases now instead of this afternoon, or had you saved that up for this afternoon?
No, Your Honor, we can do them now.
Great. Sure.
And I believe Mr. LeBlanc is now on the Zoom call.
All right.
Can you hear us, Mr. LeBlanc?
Judge,
Yes, Ms. Nelson.
I was not able to print out the second indictment. I was not able to send that to you. My remote assistance is not, my remote to that location is frozen with Odyssey.
Well, thank you. I got the first one, ending in 613. So that's a great start, and we'll go from there.
How you doing, Marcoyle?
How you doing?
Good, okay.
I'm good. How you doing?
All right, we got the audio and video working.
Great. Let's see. Okay.
Okay, so Mr. LeBlanc, we're just doing what you and I talked about yesterday afternoon, okay?
All right.
Getting the second indictment.
No problem.
So Ms. Nelson, I can get into Odyssey, but it's telling me I'm not authorized to view documents. So that's a familiar rejection. So I can look at the docket, but I can't see any documents, and
Okay,
I can't print out the other indictment. We'll work through it.
okay.
All right,
Let me see what I can do.
All right. Ready, Mr. Forte? So on the record with Mr. LeBlanc's two cases, it's 19 SC 166-613 and 19 SC 171344. Good morning, Mr. LeBlanc. Can you hear me?
Good morning.
I'm Judge McBurney. We are apparently going to take pleas in your two cases. Is that your understanding?
Yes, sir.
So, Mr. LeBlanc, this was on a calendar for 1:30 today, but we finished some other things sooner than we expected. And I asked Mr. Franklin, your lawyer, to see if you wanted to appear virtually as you are now and take care of the pleas this morning, or instead to come in person at 1:30 this afternoon. Are you comfortable proceeding remotely as you are?
Yes, sir.
Okay. So you're waiving your right to be here in court with me and with Mr. Franklin, your lawyer.
Yes, sir.
If you need to speak in private with Mr. Franklin, let me know. I'll have him step outside the courtroom and you two can have a private conversation. Otherwise, our conversations will all be on the record, okay?
Yes, sir.
In a moment, Ms. Hall, the prosecutor, is going to put you under oath. Once you're under oath, it's important that you answer her questions and mine truthfully and completely. It is just as important that if you have any questions about anything we're talking about or things we're not talking about that you have a question about, that you let me or Mr. Franklin know that you've got a question. Will you do that?
Yes, sir.
All right. When you are ready, Ms. Hall.
Thank you, Your Honor. Mr. LeBlanc, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You may lower your hand. Please state your true, correct, and legal name.
Marcoyle LeBlanc.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 24 and I got my GED.
And are you able to read, write, and understand the English language?
Yes, ma'am.
In case 19 SC 166-163, do you understand that you've been charged with I'm sorry, Your Honor, for the record, the state is no pricing reducing count one from willful obstruction of a law enforcement officer by use of threat or violence to just obstruction, misdemeanor obstruction of a law enforcement officer. The state is no pricing counts 2 and 3, which are possession of a controlled substance and schedule 3, 4, or 5 with intent to distribute, and possession of marijuana with intent to distribute. And for the second case, Your Honor, 19 SC 171344, the state is reducing count 1, which is aggravated assault, family violence, to disorderly conduct. We are no pricing count 2, which is possession of a firearm during the commission of a felony, and the remaining counts will stay.
So these are misdemeanor pleas.
Yes, Your Honor.
Okay.
Mr. LeBlanc, do you understand that you've been charged with, in case 19 SC 166613, willful obstruction of a law enforcement officer by use of threats or violence being reduced to obstruction of a law enforcement officer, as well as loitering and prowling?
Yes, ma'am.
Do you understand in case 19 SC 171344, you have been charged with aggravated assault, family violence being reduced to disorderly conduct, and simple assault, family violence, and criminal trespass?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney, Mr. Franklin, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Counsel, do you waive formal reading of both of these indictments?
So wait.
Do you waive any and all defects in the indictments, including with respect to the defendant's names?
Yes, if any, for purposes of this plea only.
Do you waive moving forward on a copy of either of these indictments?
So waived as well.
Mr. LeBlanc, have you been arrested on these charges?
Say that one more time.
The charges that I read to you at the beginning, have you been arrested for those charges in both of these cases?
Yes, ma'am.
I ask because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No,
No,
ma'am.
ma'am. We are not aware of any outstanding warrants related to this case, or to either case.
Okay. Mr. LeBlanc, has your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes, ma'am.
The maximum sentence for each of these charges is 12 months to serve. Do you understand for case 19 SC 166613, this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 12 months probation for obstruction of a law enforcement officer and 12 months probation for loitering and prowling. But the court does not have to accept that recommendation. The court can sentence you to the maximum on each of those charges and can run those sentences consecutively or one after another. Do you understand?
Yes, ma'am.
Ms. Hall, is the recommendation that those terms run concurrently or consecutively?
For this case, concurrent.
Okay.
And Mr. LeBlanc, for 19 SC 171344, do you understand that this is also a negotiated plea of guilty, which means the state will recommend to the court a sentence of 12 months probation for disorderly conduct, 12 months probation for simple battery, family violence, and 12 months probation for criminal trespass. All three probations to run consecutively. Also, a special condition of your probation is that you complete the Men Stopping Violence program. Also, if there is no violations within the first 12 months,
If there's no violation of the probation within the first 12 months and he has completed the Men Stopping Violence course, probation may be suspended.
Okay.
All right, Ms. Frank, I didn't know if I should add it there at the end, so that's why I froze. But yes, that is the other condition. Mr. LeBlanc, do you understand that the court does not have to accept that recommendation? The court can sentence you to the maximum on each of these charges and can run those consecutively like I've already explained.
Yes, ma'am.
Do you understand this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Ma'am.
Do you understand that by pleading guilty, do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
In indictment number 19SC166613, how do you plead to the charges of obstruction of a law enforcement officer and loitering prowl?
Yes.
I'm sorry, Ms. Blunt, what did you say?
I said yes.
I'm sorry. Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you. And as far as indictment 19SC171344, how do you plead to the charges of disorderly conduct, simple battery, family violence, and criminal trespass?
Yes.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
You understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 12 months from today for a misdemeanor charge to
Yes,
file
ma'am.
a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you, Mr. LeBlanc. Your Honor, as you already know, Odyssey is having issues, so I'm not able to pull up my summary of facts nor the criminal history. So I'm gonna rely on Ms. Crawford for his criminal history, as I didn't write that down. And I'm going to recite the facts as I remember them. I don't have the addresses for either since I can't pull up the documents.
We will stipulate to the fact that both incidences occurred in Fulton County.
Okay.
Thank you. Your Honor, had in case 19 SC 166613 proceeded to trial, the state would have proven that on December the 29th, 2018, officers received a call stating that two individuals were selling drugs outside of a convenience store. One of the officers arrived to the convenience store and observed the two gentlemen in front of that store. When he went to approach them, both individuals started to walk away, eventually started to run. Another officer came to the scene, which he ended up chasing behind the defendant. At one point, he got out of his vehicle and he tackled the defendant. And I I believe we've talked about this case a couple times. This is the officer who ended up breaking his leg when he went to tackle the defendant, and he is now disabled and on desk duty since this incident has happened. The state, that was all as far as the actions of the defendant. The defendant was arrested for the willful obstruction and all the charges. After looking into the case and talking with my supervisor and the defense multiple times about this case, we did come to the conclusion that there was no offer of violence or threats by the defendant. So that was improperly charged when it came into our office and when we indicted it. That's why that is being reduced to the misdemeanor obstruction. When the defendant was searched incident to arrest, there was pills found on him and marijuana. We were given information from the defense counsel that the pills were from some type of injury. I'll let the defense explain that if he wants to, but we did decide to know the 2 drug charges. The possession of marijuana with intent to distribute, it wasn't actually, it was less than a gram of marijuana. Wasn't even enough to distribute, so we did no price that count. As far as case 19 SC 171, I'm sorry, Your Honor, and as the defense stipulated too, this case did happen in Fulton County. And then on 19 SC 171344, which is also a case that happened in Fulton County on January 23rd of 2019, officers were dispatched to a location in Fulton County where they spoke with a Mercedes Chase, who is the victim in this case. The defendant is the father of her children. She told officers that he came over to the apartment complex that she was at. And when they refused to open the door, he kicked down the door and started to hit the victim. There was a allegation that there was a gun seen by one of the witnesses. Further investigation from our office, speaking with the victim and reaching out to the witnesses that was there. The witness who gave the statement to officers saying that there was a gun present during the time in which the defendant was assaulting the victim. She was not present in the room. She was merely a person that recited the events that someone else told to her, because the person who actually saw the events apparently had some type of warrant, so did not want to encounter the officers at that time. So we did decide to know that the gun charge, the defendant was arrested later on that case. He wasn't arrested that same day that the report was taken. So we didn't have any evidence that he had a gun. We didn't arrest him with a handgun or any of that. So we did decide to know that. And after speaking with the victim in more depth as to the injuries, all of them were superficial. She didn't go to any doctors or in the hospital. She didn't need any stitches. There weren't even any bruises there when the officers were talking to her when they arrived or when I was watching the body cams. And after speaking with her and her observations of the defendant and their relationship now with their children and all the information that she's given our office, we decided to reduce this case to give the defendant a chance to continue to move forward in the way in which he's moving, Your Honor. But we did, as you know, ran all these probations consecutively because there was still some violence that did go on in that apartment that day. So that is all for both of the cases. There was restitution in this case where he kicked in the door. The father of one of the witnesses was the leaseholder of that apartment. He was requesting restitution from the defendant. However, I reached out to the apartment complex. They did repair that door and they are not requesting restitution. That went through an insurance company. So that is all for that case, Your Honor.
Okay. And Ms. Hall, you or Ms. Rolak have let Ms. Chase, that would be the victim in the case ending in 344, know that Mr. LeBlanc will be getting misdemeanor probation.
Yes, Your Honor. I've spoken with her several times, and I've spoken with her since we came to the negotiated agreement.
Is she seeking any type of stay away order? I think you mentioned that Mr. LeBlanc and Ms. Chase have kids together. Is she wanting any condition for the probation to keep her safe?
No, Your Honor. She says that she's not afraid of the defendant, that she believes, in her opinion, that him going to jail for her case maybe scared him a little bit, because she said since that happened, they have not had an argument. He has just been taking care of his children. She said, I mean, she just said that he's been doing a lot better since he got arrested for this case. So she's not asking for a stay away. She actually, she actually liked the fact that we have the program for him, because she thinks it's going to make him continue to do better in life.
Okay. And Officer Terry is the officer, I think, who broke his leg trying to tackle Mr. LeBlanc. Has your office let Officer Terry know what it's planning on doing with the other case?
I believe so. I can't confirm, Your Honor. I left that up to my supervisor because I felt like she needed to be the one to speak with him about that. So that is, I think it happened already, but I'm not sure. I have not confirmed that. But that is the plan, to let him know how we decided on this case. I talked to him in the past during pandemic to let him know where we were headed, because I knew that we were headed towards misdemeanors. And that's why I wanted this last conversation to be my supervisor, because it wasn't what I expected.
And did Officer Terry share with you his view of how you were thinking the case might resolve?
No, I think I could tell there was a little frustration, because he's been affected by the case. But no, he didn't go into details as to how he felt.
But your understanding from a review of the case is that Officer Terry's injury was caused in the process of Officer Terry trying to bring Mr. LeBlanc to the ground, and not as a result of Mr. LeBlanc resisting Officer Terry in some way.
That is correct, Your Honor. I personally watched the body cam, I think at least 3 times, because Mr. Franklin wanted me to see it his way. So I kept watching it. And it was actually, I mean, the officer just, when he got to the defendant, he jumped to stop him from running. And that's when immediately he starts to complain about his leg being broke. So it definitely wasn't anything other than the defendant running, anything that the defendant contributed to.
Got it. Ms. Crawford, what can you tell me about Mr. Mr. LeBlanc's criminal history?
Judge, he doesn't have a criminal history found on him.
Okay, great. Mr. Franklin.
Yes, Your Honor. The things that I will add, just to provide a bit more detail, so the court has context as to why the charges are what they are. The possession of controlled substances, I believe, was scheduled 3, 4, or 5.
Tramadol.
To pain pills.
It is.
He received them from the mother of his child in question in the other case. He works as a warehouse worker at the Walmart facility down in South Fulton. He was also going through some kind of dental tooth pain, had access to pain pills, and took the bottle with him. And so, to the extent that having somebody else's prescription is a thing, that certainly is the issue. But it wasn't him out there trying to sell pills for whatever purposes.
But he told you those were Ms. Chase's pills.
Correct.
And that he was self-medicating because of tooth and whatever.
Yes, sir.
And why did Ms. Chase need tramadol?
I was never able to get her on the phone myself. Everything I've learned about mostly the other set of charges came from Ms. Hall.
Okay.
And transitioning to that case, we don't dispute any of the allegations as it goes towards that, Mr.
Kicking in the door and
Correct.
Striking Ms. Chase.
Correct.
Okay.
What
was the issue?
The nature of how the struggle went down, I think it's just different. I think the fact that she doesn't have any real injuries, no bruises, anything, goes more towards our kind of understanding of events, that things got physical, but it wasn't this wailing that we often visualize in our heads. They were supposed to go look at apartments or something that day. The person's home who they were at, or the house they were at, belongs to a woman who was the sister of Asha Bryant. Asha is somebody who was at the house talking to Mercedes that day, and who Mr. LeBlanc had previously been involved with. So it was an odd set of circumstances all around. He was trying to get her out, away from Asha, if you can understand, so that they can go about taking care of their business. And I think it's just kind of one of those things where she was like, leave me alone, I'll come when I'm ready. Like, no, come on, one of those kind of situations that is not appropriate, but also isn't the gravamen of what we believe we understand when we hear these kind of charges. So inappropriate behavior, but not the scary violence that we sometimes hear about. It's certainly something that is most appropriately addressed by programs such as Men Stopping Violence. And additionally, I think that's why we stack the charges on that case as opposed to just 12 months probation, as opposed to the drug case, where that entire case is running concurrent with count 1 of the violent allegations.
Okay. Mr. LeBlanc, can you hear me?
Yes, sir.
How long were you in jail on the case involving Ms. Chase?
6 months.
6 months.
Yes.
All right. And you're wearing an ankle monitor now?
Yes, sir.
Was that a condition of your bond?
Yeah, that was like I think that was a condition not for the case with Miss Chase, but the case with the trauma doll.
Okay. And you're still wearing it?
Yes, sir.
Okay. Are you still working at Walmart? At the warehouse?
No, not right now. I'm looking for another job right now.
When did the Walmart warehouse job end?
You said when did I start working there?
Yes.
That was like a month ago.
Okay. And you have not been working since then?
No, sir. I've been looking for a job right now.
Okay. Is Ms. Chase someone who you still spend time with, or did you guys go separate ways after this situation?
I mean, we didn't been our separate ways as far as the court situation, but we still been, I got the girls right now at the moment. So I've been trying to, we've been working on each other. Yeah, we we cool. We great with each other.
Okay. How many kids do you have together?
Three girls.
Okay. How old are they?
4, 3, 2.
All right. 1 a year. So does Ms. Chase work?
Yeah, that's why I had them right now, cause she works. She been doing like the DoorDash and the Lyft right now.
Okay.
But she trying to get all the way right.
Do you have
That's
any
why
questions?
I got them right now. No, sir.
Okay. Well, Mr. LeBlanc, I find there's a factual basis for both your pleas. I don't know what was going on at the convenience store. These officers showed up, you ran, and they tackled you, and the rest is history on that case. The other case is the one that I think we are appropriately focusing more on. You got upset with Ms. Chase and you didn't handle the situation the right way. I bet it was frightening for Ms. Chase. And you're going to need to handle things differently in the future if you and she get into some kind of dispute. And that's the one that I'm a little more concerned about. But I find there's a factual basis for that plea as well. I find that your pleas are both knowing and voluntary. Voluntary means no one's forcing you to enter this plea, but that you've decided after talking with your lawyer that this is how you want to go forward. Is that correct?
Yes, sir.
And a knowing plea is simply one where the defendant understands the consequences of his decision. Have you understood all the things Ms. Hall and I talked to you about?
Yes, sir.
No questions?
No, ma'am. No, sir. My fault.
Okay. Then I am going to sentence you in the case ending in 613 to 12 months to serve on count 1, which has been reduced to a misdemeanor, and 12 months to serve on count 4. Counts 2 and 3 have been dismissed by the state. In the case ending in 344, count 1 has been reduced to disorderly conduct. And I'm going to sentence you in this case on count 3. Back on the case ending in 613. Those 2 counts run concurrently with each other at the same time. So that's 12-month probated sentence.
Just to be clear, because I think you said to serve.
To serve on probation. Okay. So it's 12 months probation, misdemeanor probation total, for the case ending in 613. That was the case. What was the police agency?
This would have been, I think the area, that part of Camp Creek is College Park. I think
There's that indictment.
the East Point College Park.
It's right here. Officer College Park. So the one with College Park Police, that's 12 months probation, misdemeanor probation. The case ending in 344. Your sentence as to count 3 is 6 months, and that is to serve, but it will be reduced to the time you already served. Count 1, the sentence is 12 months. It'll be probated. That will run consecutive to count 3. And count 4, the criminal trespass, that was breaking the door or damaging the door, that will be 12 months probated consecutive to count 1. So it's a slightly different sentence. It's 24 months probation following the 6 months to serve. You've already served the 6 months. You're not going back to jail, and you'll be able to get rid of that ankle monitor. A special condition of your probation in the case ending in 344 is that you complete the Men Stopping Violence, domestic violence program. A second special condition is that you have no violent contact with Mercedes Chase. Chase. So you can still spend time with her, but if there are any issues with her where the police get called, not only might you have new charges, but that would be a reason to revoke some or all of your 24 months of misdemeanor probation in that case. And the 2 cases will run concurrently with each other. So the overall sentence is 24 months of misdemeanor probation. Ms. Hall, anything else you want to add in connection with Mr. LeBlanc's sentences?
No, Your Honor.
Mr. LeBlanc, if you were here in court, you would sign your 2 indictments indicating that you were pleading guilty, but you're wherever you are, and I've got your indictments here. I actually got to print the other one out as well. Do you authorize me, Mr. LeBlanc, to sign the indictments for you?
Yes, sir.
Mr. Franklin, can I sign for you?
Yes.
And Ms. Hall?
Yes, Your Honor.
Mr. Franklin, anything else in Mr. LeBlanc's 2 cases?
I don't believe so.
Ms. Nelson, how are we going to connect? Oh, I don't see Ms. Nelson on here. Maybe she's iPhone. Are you iPhone, Ms. Nelson?
Well, I don't know which phone I am now, Judge.
Yeah.
I will make sure that I send the misdemeanor probation information to Mr. Franklin. He can pass it on to the client.
Great. So, Mr. LeBlanc, you're going to hear from Mr. Franklin in the next day or so about what you need to do to plug in with misdemeanor probation, okay?
Yes, sir.
You have any questions about anything, Mr. LeBlanc?
No, sir.
All right, good luck with the kids and finding a new job.
All right, thank you.
Take care, Mr. LeBlanc.
All right.
I think that's it. Anything else from you, Mr. Franklin?
No, sir.
All right. Ms. Hall, anything else?
Nothing further from me, Your Honor.
All right, well, thank you, everyone. Before everyone disappears, let me just check the calendar. Tomorrow is drug court in the morning, and then we've got our Zoom calendar in the afternoon. We swapped with Judge Barwick, I think, so that we didn't miss a Zoom session. So I've got that down as 1 o'clock for our Zoom calendar. Everyone's looking confused.
No, I knew we had kind of what time it was.
Okay, I mean, I don't know who's on it, but
If it was 1 o'clock already, I'll be here at 9.
it's 1 o'clock. Starting out with some final pleas. Looks like we've got CWAC and a murder case of Miss Snyder's. A lot of final pleas. Anyway, you guys got the calendar. You've had it for weeks. I'm sure you're ready. And we'll handle that. That's in the afternoon. And then Thursday, we don't have anything in court. We're all busy, but we'll be back together on Friday the 16th. So I'll see everyone around 1 tomorrow. Thank you.
Bye, Your Honor.